Okay, let's go ahead and start. So welcome, I'm Rob Thompson. I'm a partner with Counts Thompson in the Woodlands, and I want to thank you for coming to this live Facebook Q&A. This is the first one I've done, so I'm a little bit nervous, but it's going to be good. I'm excited for 2018. It's going to be a great year. So why am I doing this? I'm doing this to give information to business owners who are looking for clarity about how you should organize your business. So what we're going to do today is we're going to discuss some of the most popular business entity types. I'll tell you what I think is good or bad about each one of those, and then I'll describe why I believe that the LLC is the best choice for the vast majority of small businesses. Spoiler alert. And then I'll give you a list of 5 big mistakes that I think most business owners are making and how to avoid them. And then I'll open it up for questions and answers. You can ask me anything you want. And I'll try to answer your question. Just if you ask me about kittens or unicorns, you may not be satisfied with your answer, so be forewarned. All right, let's get right into it. Let's talk about, lost my marker. Let's talk about the various entity types that are available to you as a small business owner. So the most popular, going back in history, the last 50 years or so, the most popular that you probably saw was the partnership. Or the most common anyway. And then after that, we've got the corporation. And then the more recent development, the LLC. And some people organize as a trust as well, but that's less common. So I'm really just going to talk about the most common forms. So let's go ahead and talk about the characteristics of each of these, starting with the partnership. A partnership is defined as when 2 or more people engage in business for profit. So that's the common law definition of a partnership. That's a general partnership. If you want a limited partnership or a limited liability partnership, then you'll have to file something with the Secretary of State. And that involves filing fees. You should also have a partnership agreement. But a partnership may or may not give you limited liability, just depending on which of those options you choose. So may have limited Can y'all see that okay? I know my handwriting is not very good on this thing. Okay, I'm being asked to move the board a little closer. Let's do that. If it falls over, it's your fault, Jerry. Just kidding. Is that better? If you're watching it on your iPhone, it's probably going to be hard to read. All right. Better? Okay. All right, so limited liability. When we say limited liability, we're not talking about no liability. We're talking about your liability is limited to your investment in the company. So for a partnership, if you've set it up to be a limited partnership or a limited liability partnership, depending on what type of interest you have, you may have limited liability. Your liability may be limited to your investment. However, the caveat, a general partnership does not have limited liability. So if you are a general partner in a limited partnership, the general partner has unlimited liability. That means the general partner is going to be personally liable for anything that the entity does wrong, any liabilities of the entity. If you have a limited liability partnership, then that doesn't apply. But if you're a general partner, so that's why you'll see limited partnerships that have a corporation as the general partner. So you've got, that unlimited liability is mitigated by the corporate shield there. So it adds another level of complexity, which is why it's not as popular now as the LLC. Well, that's one of the reasons. There are other reasons, but that's one of them because it's easier to get that limited liability shield. What else? Tax. Let's talk about tax. So in a partnership, Partnership is a flow-through entity, and that means that all the income from the partnership is going to flow through to your personal tax return, whatever form that takes, your 1040 of whatever variety. And generally speaking, you're going to pay the self-employment tax on all the income from the partnership, unless it's a limited partnership and you have only a limited partner interest and you don't work in the business. So correct me if I'm wrong on that if you're a CPA and you're watching this, but I think that's how it works. And that's not flexible. So it's not as flexible as the LLC. Let's talk about the corporation. What are the characteristics of a corporation? First of all, you've got shares. Your ownership in the corporation, it comes in the form of a shares of stock in the corporation. So you give the corporation money in exchange for a piece, which is the shares. So your liability is limited to your investment in those shares in a corporation. What else? You've got complex structure here. Why? And there are some caveats with a closed corporation or a small business corporation, but every corporation is going to have shareholders. Those shareholders are going to elect a board of directors who in turn elect officers. The officers are going to manage the day-to-day operations of the company. So if you're a one-person operation and you have a corporation, you fill all three of those roles. So it's a lot more complexity. There's a lot more work that goes into maintaining that than most small business owners want or need, really. You've got to have bylaws, you've got to have corporate resolutions, you've got to have your annual meeting and all that stuff. For tax purposes, you've got some options, really just two. You can be taxed as a C or as an S. So the default treatment is the C Corp status. Okay, I'm just looking at the questions coming in. Jerry's wife is an independent contractor for an education company. Does she need to set up an LLC? That depends. We'll get to that. Let me get through this and I'll answer that question in just a minute, but don't let me forget. So when you set up a corporation, the default status is the C status, and when you have a C corporation, there's taxation at the entity level, and then there's the profits that are distributed out to the shareholders get taxed at the shareholder level as well. So on that shareholder's personal tax return. So, and the highest rate now is 21%. It's graduated. That's come down from 35%, but that doesn't apply at the S level. So if you're a small business owner, most small businesses choose the S corporation status because it's just more advantageous from a tax perspective. We're looking at whether this reduction is going to make a difference for a lot of businesses that have a little bit more complex operations. My thinking is double taxation is double taxation. In general, it's probably going to be better still to have the S taxation if you're organized as a corporation. So those are your only two options here. You still have the complex structure, but let's move on to the LLC. So the LLC is kind of a hybrid entity that emerged in 1977, and it's really gained popularity. The vast majority of new businesses that are formed in the U.S. today are limited liability companies, and that's for good reason. And because you've got all the good things from a partnership, the simplicity of the management structure, and then you also have some flexibility here that exists in the corporation as far as the tax treatment. And you've got what I think is superior asset protection features in an LLC over the corporation. So let's talk about that. So limited liability. Can't spell. So in an LLC, if you've got it structured correctly, your liability is limited to your investment in the company. Very similar to how a corporation limits your liability. However, if you've got a personal creditor or a judgment against you personally, and it's a situation where you don't have insurance to cover the loss, they may be able to seize personal property. if it's not exempt by the homestead exemptions. Texas in particular has very strong homestead protections, but things like securities that are not in a qualified account are going to be subject to seizure. So stock in a corporation is subject to being seized. So that means if you have a personal judgment against you, then your creditor can institute what's called turnover and receivership. They can seize the stock in your company and liquidate it to satisfy that judgment. If you've got your LLC set up correctly, they can't do that to your LLC. The best they can do is get a charging order, which is essentially a lien against distributions that you make from the LLC. Now, more sophisticated strategies involve, sliding scales and multiple LLCs that mitigate that risk. But for most business owners, just the ability to keep running their business is enough to motivate them to use the LLC structure. So we're going to call that limited liability plus charging order only. The other thing that you can do with the limited liability company that you can't do with a corporation is you can put a provision in there that if a member acquires an interest by judgment, or if it's as a result of a debt, that they don't get to vote. And creditors don't like that. If you have an interest in a company and you want to liquidate it, but you can't vote, you're dead in the water. Partnerships, incidentally, can also use that charging order only protection. The structure, management structure. I wrote simple structure, but that's the default. You can make it as complex as a corporation or however complex you want. The point is that there is unlimited flexibility with how you want your LLC management structure to be. You can make it look exactly like a corporation. You can have it managed by the members like a general partnership, or you can have some hybrid where it's a board of managers or maybe one manager. Most of the companies that I set up have one manager. So it looks a lot like a limited partnership where you've got the general partner who is managing the day-to-day operations, but that person in an LLC is called a manager, and there's no liability, or it's limited liability. So, and the other thing with that is they don't have to have any ownership interest. The manager doesn't have to be a member necessarily. So it's very flexible, and it's you can tailor it to your specific needs and wants. Okay, and then for tax, the other thing with LLCs is the tax flexibility. I hope you can read that. It's chicken scratch. But so tax flexibility in an LLC, the default is to have it taxed. If it's a single member, then it's a disregarded entity. So it's taxed as if you're a sole proprietor. If you have more than one member, then it's taxed as a partnership. But you can elect to have it taxed as a corporation, either a C or an S. So with an LLC, you have all the choices that are available to you. I usually recommend S Corp taxation for a small business because you get the benefit of not paying the self-employment tax on all of your income. If you take a reasonable salary and then take excess profits on a K-1 distribution, then that's going to lower your tax bill in most cases. Talk to your CPA just to make sure you've got that set up correctly if that's what you want to do. But those are the reasons that I like the LLC, because it's flexible, you get superior asset protection, and it's a lot easier to manage. So, and then we're going to transition to the next part. So this is the article that I was talking about. I just put this together. Actually, I've been working on it for over a year, but I just finished it. I may change it again, but here, I'll give you a little sneak peek. I think I can share my screen. Maybe I can't. Anyway, if you click on that link, you can download a copy of this. It's all original. I wrote the whole thing. It's 6 pages, so it's a pretty quick read. And that's large print, Jerry, for you. All right, so the next thing I want to talk about is the 5 big mistakes that I mentioned. And we'll just kind of go through in order, and I'm going to use this as a guide. So the first big mistake that I see is when business owners set up their company, usually an LLC, excuse me, they file their certificate of formation with the Secretary of State's office, and they don't do anything else, and they think they're done. But that's not true. There are a few more steps that you need to take in order to get the full benefit, the limited liability, the asset protection features of that company, because that really is the point of setting up a company. So, and then the second big mistake is failing to hold an organizational meeting. So you've got to when you form your company and you've got multiple members, even if you don't, you need to go through the formality and have an organizational meeting and document that, because every little detail that you can show the court to say, yes, we're observing the formalities of operating a legitimate business, is going to be another brick in the wall of combating or defending against the plaintiff's attorney who wants to breach that corporate veil and get to your personal assets. So you need to observe the formalities. So when I set up a company for a new business, we'll have a formal around the conference table organizational meeting, and we'll sign the resolutions, and we'll make it we'll formalize it, we'll document what we're doing, and we'll make sure that we do it by the book. That's not a step that you want to skip. All right, so the third mistake is not having a company agreement. Probably the majority of LLCs that are formed in Texas are just a certificate of formation. They don't have a company agreement, and that's bad because if you read the LLC statute, a lot of those provisions assume that there is a company agreement. So you really do need one, and if you're lacking that, then you're going to run into trouble. So I'll give you an example of why. Let's say you've got 2 partners, and the 3 of you have decided to set up an LLC and go into business. 6 months down the road, one of your partners decides he can't handle this, and he's going to go back to work for somebody else at his old job or a new job or whatever. So the default statute is when somebody leaves the LLC, it dissolves. There's no more LLC. It's like a partnership. It's gone. Unless your company agreement provides otherwise. So a lot of those provisions in the statute are permissive, which means that they say unless your company agreement says otherwise. So you don't want the statute to control something like that. You want to be in control of it yourself. So have a company agreement. The fourth mistake that I see a lot is failing to obtain a tax ID number. I don't see this quite as often, but it's fairly common. You need to set up a tax ID number, a separate tax ID number for your business. Again, it goes toward keeping it separate, because if you don't get a tax ID number, then you can't avoid mistake number 5, which is commingling funds. If you're commingling funds of your business and your personal affairs, then you've got a really big problem if something goes down in your business, because the likelihood of veil piercing just went way up. So make sure you don't do that. Don't commingle your funds. Make sure you get your tax ID number and you set up separate bank accounts for your business and operate your business out of those bank accounts. And don't observe. You want to observe the formalities. Don't play fast and loose with that stuff, because it's dangerous. And that covers all 5 mistakes. So I got my notes written on the back of this thing, so I keep my roadmap. All right, let's open it up for questions. So we'll take Jerry's question first. Let me scroll back up here if I can see it. Okay, Your wife is an independent contractor. Does she need to set up an LLC? What state are you in, Jerry? You're not in Texas, are you? Here, let me post this link in here. Some of you are asking for it. All right. So I can give you the answer for Texas law is I would go ahead and set up an LLC and do an operating agreement because even if she's the only person operating in the business, anything that happens in the business that she does, she's going to be personally responsible for. She's personally liable for her own torts. The contracts are a little different. If the LLC is the contracting party, then only the LLC is liable for that. So you do get some asset protection, some limited liability, even if you're the only person operating in an LLC. For tax purposes, that is a CPA question. It probably isn't necessary for tax purposes. It may be simpler to not do it. But if there's a lot of revenue in a company, then you can reduce your tax bill by taking a reasonable salary on a W-2 and taking the excess profits on a K-1. So there really is a tax reason for doing it if the revenue is high enough. And there's a liability reason to do it as well. So it's really a personal choice. It kind of depends on this, the income stream and the amount of revenue that's coming through, whether it justifies the expense of setting up an LLC. So, and Louisiana law is going to be a little different than Texas law, but there are a lot of similarities too. So find a Louisiana attorney. I can help you with that offline if you want me to. And they can answer your questions more specifically. Any other questions? Did everybody see the link? It's a pretty cheesy landing page. It's kind of funny. All right, what other questions do we have? All right, I see Kyle checked in. Gonna finish watching later. I'll record this, so if anybody wants to come back and watch it later, you can. Hi, Cheryl. We're just doing Q&A. I did a presentation. Look, I wrote all this stuff down. Any more questions before we're done? I give you a few more seconds. Well, everybody, I appreciate y'all checking in and watching and staying with me. And I'm going to do this again soon. I don't know when exactly, but I'll do it the same way. I'll put up an announcement so you see when it's going to happen. And thank you for watching, and I'll see you soon. Bye-bye.